So without further ado, let me turn things over to Joel Alicea, who will be moderating our panel.
Thank you, Lee. Welcome to our first panel of the day, Originalism, Birthright, Citizenship, and the 14th Amendment. I'm Joel Alicea. I'm a professor at Catholic University. Very pleased to be moderating this discussion. I'm just going to set up our conversation, introduce our four panelists briefly, and then turn things over to them. So on January 20th, 2025, shortly after taking the oath of office, President Donald Trump signed Executive Order 14160. The order interpreted the 14th Amendment's Citizenship Clause, which states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." The President interpreted the Citizenship Clause to, quote, "not automatically extend to persons born in the United States when that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth, or when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth." Accordingly, the President directed all federal agencies to not issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship to any person in the two categories just described. The effect of the President's order, if implemented, would be to narrow the scope of birthright citizenship as it has been understood, at least in recent years, up until now. President Trump campaigned in part on a policy of refusing to recognize the citizenship of children born to aliens unlawfully present in the United States, so his order wasn't terribly surprising. It's an attempt to follow through on that campaign promise. Several lawsuits around the country immediately challenged the legality of the President's order. They alleged that the order violates the Citizenship Clause, but they also allege that it violates a provision of the Nationality Act of 1940, codified at 8 U.S.C. 1401A, which mimics the language of the Citizenship Clause in declaring who shall be considered a citizen for purposes of federal law. Courts granted universal injunctions against implementation of the President's order, but the Supreme Court partially stayed those injunctions in Trump versus Casa. The court did not, at the time, address the merits of the legality of the President's order, holding only that universal injunctions go beyond the judicial power vested by the Judiciary Act of 1789. The same day that the court decided Casa, a group of plaintiffs filed a new lawsuit challenging the birthright citizenship order in the District of New Hampshire in a case now called Trump versus Barbara. The district court provisionally certified a comprehensive class consisting of all individuals born after February 20th, 2025, who fell into the two categories of persons described in the President's order. The district court entered a preliminary injunction against enforcement of the President's order, and a little over a month ago, December 5th, 2025, the Supreme Court granted certiorari before judgment in Barbara, agreeing to resolve on the merits whether the birthright citizenship order violates the Citizenship Clause of the 14th Amendment and Section 1401 of the Nationality Act. The Solicitor General's opening brief is due later this month. The case has not yet been set for oral argument, but it seems likely it will be set for April with a decision this summer. The President's birthright citizenship executive order has sparked a heated debate in our politics and in the courts, but it has also led to an outpouring of scholarship on the original meaning of the Citizenship Clause. While there are stare decisis arguments that may be important to the resolution of Barbara, and I'm sure we'll touch on those today, because this court is composed of a majority of justices who self-identify as originalists, it is likely that the original meaning of the Citizenship Clause will play a role in the court's analysis. And when the court turns to the scholarship on the original meaning of the Citizenship Clause, it will find that some of the best work from varying perspectives has been done by the four panelists we are privileged to have with us today. Rather than providing their complete and impressive bios, I will keep the intro short and point you to some of the relevant scholarship that they've produced on this topic. So I'll introduce them in the order in which they're going to speak to my left. So Keith Whittington is the David Boies Professor of Law at Yale Law School. His primary article on this topic is titled "By Birth Alone, the Original Meaning of Birthright Citizenship and Subject to the Jurisdiction of the United States." Ilan Wurman is the Julius E. Davis Professor of Law at the University of Minnesota Law School. His primary article is titled "Jurisdiction and Citizenship." Kurt Lash is the E. Claiborne Robbins Distinguished Chair in Law at the University of Richmond School of Law. His primary article is titled "Prima Facie Citizenship, Birth, Allegiance, and the 14th Amendment's Citizenship Clause," which is forthcoming in the Notre Dame Law Review. Finally, Amanda Frost is the David Lurton Massee Jr. Professor of Law at the University of Virginia. She has several articles relating to this topic. She was writing about this long before it became a big source of news. I'll just note one article, By Accident of Birth, The Battle Over Birthright Citizenship After United States versus Wong Kim Ark, which was published by the Yale Journal of Law and Humanities in 2021. Each panelist will speak for 8 minutes of opening remarks, then they'll have 3 minutes to respond to each other, and then I'll have a few questions to facilitate before turning it over to you for Q&A. So we will start with Professor Whittington.
Thank you. And thanks for you all for coming out at a ridiculously early time. And I appreciate the panelists being willing to engage in this conversation. In my opening, I just want to spend some time talking primarily about the common law rule that emerged out of England, had largely been adopted in the United States, was increasingly contested in the years prior to the Civil War, and I think ultimately was attempted to be codified by the drafters of the 14th Amendment. I should say at the start that questions of unauthorized immigrants was not on their mind. It was not really part of the legal background that they're immediately concerned with, not as part of the set of applications that they're primarily focused on when they're drafting the 14th Amendment. These are issues and potential applications of the rule that come later. This is not a particularly unusual or surprising situation for how law works in general. So as a consequence, it's important to think through what the underlying rule is, and then separately, we can think about what the correct application of that rule ought to be for the kinds of situations in front of us. And I won't have anything to say about the application of the rule to the specifics of President Trump's order, although I think the implications are clearly there, but I just want to talk about it in my initial talk. Part of my focus, though, really is in part generated by, I think, an important question that was raised in an op-ed in the New York Times by Ilan and Randy Barnett soon after President Trump issued his order, which is to say that it's important to think through and identify whether or not there is a rule and consistent principle that underlies the birthright citizenship set of claims in the text of the 14th Amendment specifically, and how do we think about the qualifications and limitations of that rule in general? Is it just the case, because it's well recognized that there are a set of exceptions to the general default assumption of birthright citizenship, and then the question is, well, these are just ad hoc examples, in which case we can imagine creating more if we wanted, or maybe there are more floating out there that we haven't really thought through. So it's important to identify and think through what the rule and principle is that underlies the 14th Amendment, and that will then guide us in trying to think about what the exceptions are and qualifications to that principle might be. And so my paper is centrally concerned with trying to identify sort of what is that underlying rule and principle, what's the logic of that rule and principle, and as a consequence, why is it that the standard kinds of exceptions that the common law recognized, which are very few, make sense within the logic of that rule, and why they don't naturally extend to the kinds of contemporary applications that some now want to claim. It's worth noting as well in the beginning that, like all features of the English inheritance as it's carried over into the American context, and features of the common law particularly, there are questions about how compatible that English inheritance is with the American form of republican government and constitutional system that we were establishing. And there's various features of the common law that Americans debated over and modified to some significant degrees as they carried them into the American context. And so we shouldn't think that just because we might identify what the English principles and common law rule was relative to birthright citizenship, that by itself means it carried over naturally and completely into the American context. And I think there was an important element of the British system of thinking about citizenship that was not carried over, that was regarded as distinctly feudal by the Americans from the very beginning of American independence, coming out of the revolutionary debates, and as a consequence was explicitly rejected universally by Americans and not recognized in American law. That has nothing to do, though, ultimately, with the kinds of rule that does wind up getting carried forward and embodied in the 14th Amendment. The part that was regarded as particularly feudal and rejected by the Americans was the English assumption of perpetual allegiance, that once you are a natural citizen or subject for English purposes, it was impossible to set that aside on your own. Only the sovereign could release you from those bonds of allegiance and obligation. For the Americans, on the other hand, they wanted to recognize a right of expatriation, the possibility of setting aside those former bonds of allegiance on the voluntary choice of the individual subject or citizen. That was central to the American view, part and parcel of the revolutionary inheritance, and as a consequence, that vision of perpetual allegiance was set aside. But what was preserved and carried forward in American law was the understanding of how one became a natural-born citizen in the first place, which was already articulated in the English common law and basically accepted in its entirety into the American system, although the 14th Amendment is trying to make one particular, I would say, clarification, one might think modification of that traditional British inheritance, reflecting the peculiarities of the American context. So that English inheritance, that English rule as carried over to the United States, was articulated, for example, by Lincoln's Attorney General Edward Bates in one of his opinions about citizenship in the United States. As he characterized it, nativity furnishes the rule, or every person born in the country is prima facie a citizen. This was the English rule as well. This had been accepted as the American rule, then been carried forward to Bates's time. It was articulated early on by the treatise writer Chancellor Kent, whose views about these were highly influential all through this period, including during the 14th Amendment ratification, in which Kent, in a later edition, characterizes this as natives or persons born within the jurisdiction and allegiance of the country, in our case, of course, of the United States. And why this language, though, of jurisdiction becomes obviously quite important. It was important for the English common law rule, but becomes quite important, of course, because it's embodied in the text of the 14th Amendment, and it goes to the potential exceptions to the basic rule that if you're born in the country, you're a citizen. And the concern here is it's not enough to simply be born in the land of the United States, but you also have to be subject to the governance of the United States authority, or as the English law would characterize it, within the king's dominions. This had two particularly important implications in terms of qualifications and exceptions. One is that foreign ministers who were within the scope of the territory were not subject to the king's authority and governing authority, and as a consequence, they were accepted from this rule. Children of foreign ministers, because they retained their obedience to a foreign king, their children likewise were not natural-born subjects of the sovereign under which they happened to be born, whereas other aliens who come into the territory of a sovereign, the English king, for example, were subject to the obedience and governing authority of that king, and as a consequence, their children were natural-born citizens. The other related exception that was commonly referred to are invading armies, which likewise are rejecting the governing authority of a king. Any children born within the occupied territory of an invading army likewise were outside the governing authority of the existing sovereign, and as a consequence could not be a natural-born citizen as such. What's crucial to these understandings and definitions is a concern with questions about governing authority. Who is subject to the rules of the territory. It's not enough to be simply born within the territory, but you also have to be subject to the rules of the territory, and likewise we understand the exceptions and qualifications and limitations as to who a natural-born citizen is by that question of who's outside the scope of the governing authority of the government in question, in our case, of the federal government. Thank you.
Thank you, Keith. Ilan?
Great, thank you so much for having me here. So Keith's argument is that the common law rule was mere birth alone, or that nativity furnished the rule, and therefore ambassadors, the children born of ambassadors and invaders, were exceptions to the rule. But what I show in my work, or try to show, or argue, I should say, is that that actually wasn't the rule, and that ambassadors and invaders weren't actually exceptions to the rule, but rather fell outside the scope of the rule. So what I try to show in my work is that the test was never actually birth alone. If you read the sources very carefully, they say birth on the sovereign soil and under the protection of the sovereign, and more precisely, born to parents who are under the protection of the sovereign, in exchange for which protection they gave allegiance. This was a mutual compact between sovereign and subject. These parents could be aliens. They could be aliens present in the realm who were there under the sovereign's protection and owed what was called the local allegiance in exchange for this local protection while in the realm. So why were the children of invaders not subject to this rule? Well, because as Sir Edward Coke said in Calvin's case, though born on the king's soil, such children were not born under the ligeance of a subject, under the connection of a subject. That is, their parents were not subjects of the king, and were not born under the protection of the king. In other words, your parents had to be subjects. Aliens could be subjects of the king. That's what Coke says in Calvin's case. They exchange a local obedience in exchange, or a local allegiance in exchange for this local protection. So again, the reason that the child is not a citizen is because not born, although born on the king's soil, not born under the ligeance of a subject, right, to parents who are subjects, nor born under the protection of the king. That is almost exactly what Coke says in Calvin's case. William Blackstone similarly explains the exception for ambassadors. Although the child born of an ambassador is born in another sovereign's land, the father is understood not to be within the allegiance of the sovereign, right? There's not this mutual compact of protection and allegiance, and so Blackstone says it is held also of the child represented by the father, the ambassador. So the rule has always been not birth alone, but birth on the sovereign soil to parents under the sovereign's protection. Here's how Joseph Story explained it in his concurring opinion in the famous Inglis case. Nothing is better settled at common law than the doctrine that the children, even of aliens, born in a country, while the parents are resident there under the protection of the government and owing a temporary allegiance thereto, are subjects by birth. That's the rule. Now, ambassadors and armies, to summarize, are not exceptions at all, but rather fall outside the scope of the rule, because the parents are not under the protection of the sovereign. So that's piece one. Piece two that I wanted to talk about is, how does this apply to unlawfully present aliens? We don't know for sure because there was no case, and I'll explain why momentarily. But what my scholarship has tried to show is that in the relevant period, the king's protection could only be extended to an alien in one of two ways: through a grant of a formal legal document called a safe conduct, or through statutory permissions to enter. So let's start with safe conducts. Safe conducts were all over. There are hundreds and hundreds and hundreds of these, and all use the language of, or almost all use the language of protection. So it would be really redundant to cite more than a few examples, but here are some. A safe conduct from 1157 granted merchants from Cologne the right to enter the country and said they would be taken under the king's custody and protection. In 1316, the king issued letters of safe conduct to some French knights, which stated that they were taken under our protection. The patent rolls have hundreds of these examples. One from the reign of Henry III gave a safe conduct to William of Wynham that stated he has letters of protection for himself and his men when they come in the land and power of the king with their goods and merchandise. So Blackstone summarized safe conducts as follows: during the continuance of any safe conduct, either express or implied, the foreigner is under the protection of the king and the law. Now, eventually, safe conducts gave way, except for enemy aliens, which I'll talk about if I have time, because the statutes replaced safe conducts, and statutes granted general permission for aliens from friendly countries, countries not at war with England, to enter the realm, and expressly extended them protection. So Magna Carta has a chapter that provides safe and secure conduct or protection to aliens unless they have been previously and publicly forbidden. which is interesting. The Carta Mercatoria of 1303 was a general grant of safe conduct to merchants from several European provinces, which granted them our protection. My favorite example, because it's so clear, a 1353 statute from the reign of Edward III provided as follows: merchant strangers may safely and surely, under our protection and safe conduct, come and dwell in our said realm. So it is true that aliens with permission to be in the realm were understood to be under the protection of the king, and that is why Cook and Blackstone and others explained that their children born in the realm were natural-born subjects. That is because with the king's permission came the king's protection. Although these were aliens in amity because their nations happened to be at peace, that was not the decisive factor. The decisive factor was whether the parents were under the sovereign's protection, and the statutes presumed that aliens from friendly countries had permission and therefore protection. That they happened again to be from friendly countries is honestly somewhat irrelevant. Neither Cook nor Blackstone compels the conclusion, one way or another, as to whether aliens from friendly countries, but who did not have permission to enter, would have been under the sovereign's protection. I think the common law rule and the various evidence about statutes and safe conduct suggest that they would not actually be included. Okay, so I think in saying this, I explained the difference between my argument and Keith's argument. So let me just say that he focused less on this today, but in his paper, he explains the ambassadorial and armies exception by citing Vattel, who says that, well, they aren't, in a sense, exceptions because ambassadors and armies are held to be on foreign soil, this fiction of extraterritoriality. And so Keith, again, didn't rely on it today as much, but he does in his paper. But Vattel, he does say that, so that's some counter evidence to my position, but Vattel is not a common law writer. That's not how Cook describes it. It's not how Blackstone described it. Cook specifically says, in Calvin's case, when he's talking about the children born of invading armies, he said, although born on his soil, although born on the king's soil, they were not born under the legiance of a subject or under the protection of the king. So there's no fiction of extraterritoriality in Blackstone. There's no fiction of in Cook. There's no fiction of extraterritoriality in Blackstone. In his paper, I think it's an important point, so I'll mention it. Lynch v. Clark is often taken for this proposition that the status of the parents is irrelevant, and Keith talks a lot about that more generally, not just in relying on Lynch. Again, I think if you look at Blackstone and Cook, that's quite clearly not correct. And again, Story says, while children born in the country while their parents are resident there under the protection. And Lynch v. Clark is not to the contrary. The question in Lynch v. Clark is whether the parents had to be citizens, the continental European rule. And the judge in Lynch v. Clark says, no, of course not. They don't, we don't care what the political condition of the parents are. And that's true. That's the common law. They don't care if you're alien, because aliens could be under the protection, but they still had to be under the protection of the sovereign. Okay, I'm running out of time, so let me just say one thing. What does any of this have to do with jurisdiction? The interesting thing is I think we're all talking about the common law here. But there's one thing I argue in the paper is that permission was necessary for protection, and that protection was a precondition to jurisdiction, or to amenability to the sovereign's jurisdiction. So there's a case from the War of 1812 called Clark against Morey, where there's a British subject, we're at war with Britain, and the question is whether he can sue on his contracts, whether his contracts are valid and he can access to the courts. And Chancellor Kent summarizes the law of nations on the question and says the following: a lawful residence implies protection and a capacity to sue and be sued. I don't have time to go into it in my opening remarks, but once you know to look for the connection, being outside the sovereign's protection may have subjected you to the sovereign's criminal jurisdiction. It didn't mean you could have access to the sovereign's courts. It didn't mean you had a capacity to sue and be sued, or could sue on your contracts. So that is the second piece of the puzzle. There's a connection to jurisdiction, and maybe we'll get into that later. Thank you.
Thanks, Ilan. Kurt?
Good morning, everyone. Thanks to the Federalist Society for putting on the panel. Great to see my fellow panelists, to see once again at the Federalist Society, such a wide array of positions on such a hotly debated topic. And Joel, thank you for moderating. Talking about the Citizenship Clause of the 14th Amendment this morning, we're obviously focusing on the second requirement. You have the two requirements that To be a natural-born citizen, you have to be born in the United States, but also born subject to the jurisdiction of the United States. And we're taking different approaches here into determining what the meaning of that second requirement is. And I think there are three basic approaches that you can take to investing meaning in those words. One approach would stress the reasoning in major precedents like Wong Kim Ark, kind of a jurisprudential settlement, perhaps, since that case was handed down. A second approach would look further back into history and would emphasize doctrines that emerged at common law. I think we've heard a couple of presentations that use that approach. A third approach focuses on the statements of the framers and the ratifiers who are actually responsible for adding the text to the Constitution. And that has been the focus of my work in seeking that original understanding. And in this particular case, unlike debates over the Privileges or Immunities Clause, the framers and ratifiers of the 14th Amendment actually engaged in lengthy, detailed debates regarding the meaning and theory of natural-born citizenship. And during the debates of early 1866, and national newspapers published these discussions and debates on a daily basis, which ensured that the ratifying public was fully informed about how the text was developed, what the framers understood the text to mean, and why Republicans advocated its ratification. That public discussion of natural-born citizenship did not begin with the discussions of the 14th Amendment. As Jacob Howard reminded his colleagues when he introduced the Citizenship Clause to the Senate, he began with the explanation of, quote, "The question of citizenship has been so fully discussed in this body as to not need any further elucidation," end quote. Howard was referring to the extensive debates over natural-born citizenship that had already occurred during the passage of the 1866 Civil Rights Act. Those initial debates established the basic Republican theory of natural-born citizenship, the theory that they eventually wrote into the text of the 14th Amendment. And during ratification, Republicans repeatedly assured the ratifiers that both the original Civil Rights Act and the 14th Amendment both communicated the same theory of natural-born citizenship. So what was that? What was the Republican theory of natural-born citizenship? I think the clearest and certainly the most widely published articulation of that theory came from 14th Amendment framer, Ohio Representative John Bingham. According to Bingham, every human being born within the jurisdiction of the United States, of parents not owing allegiance to any foreign sovereignty, is, in the language of your Constitution itself, a natural-born citizen. That's it. That's the Republican theory of natural-born citizenship and its two fundamental requirements: birth in the United States and allegiance to no other government than that of the United States. That's the principle that was communicated by the words of the 14th Amendment as well. As 14th Amendment framer Lyman Trumbull explained in words that are as clear as you get in originalist scholarship, quote, "What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else," end quote. That short definition of natural-born citizenship accomplished several major Republican goals. First, it erased Dred Scott's race-based theory of citizenship. Second, it would force states to recognize the equal citizenship of resident Black Americans. And third, the language excluded members of Native American tribes, since tribal parents were presumed to maintain an allegiance to what Republicans called the quasi-foreign government of the tribe. Now, I know that a number of scholars, including Keith and others, reject an allegiance-based reading of the clause, and they argue that being born subject to the jurisdiction of the United States originally meant being born subject to the lawful or sovereign authority of the United States. I think, Keith, you called it the governing authority. In fact, there were members of Congress that had that particular reading of subject to the jurisdiction, but they were Democrats. Republicans, however, had a very different understanding. Democrats believed that the text might make tribal Indian citizens, since all manner of tribal affairs fell within the scope of federal authority, including intra-tribal civil and criminal matters. Republicans responded by explaining Democrats misunderstood the text. Yes, federal law reached all manner of tribal affairs, but all such regulations came by way of treaties with the tribes, not by way of Congress's general legislative authority. This treaty-based regulatory approach reflected the quasi-foreign status of Native American tribes. Absent formal dissolution of their tribal allegiance, Native American parents and their children maintained an allegiance to a foreign sovereign, and so were not born subject to the jurisdiction of the United States, at least not according to the Republican understanding of the text. Tribal families that crossed the borders into the United States without authorization were subject to federal detention and relocation, and this was true regardless of hostile action or intent, or whether they otherwise followed the local laws of the state or territory. The presumed foreign allegiance of those illegally present families remained unless formally dissolved through available pathways of naturalization. That was the situation in 1866 at the interior borders that were established by treaties. The situations at the exterior borders of the United States at the time was legally the opposite. Chinese immigrants were free to enter the United States and reside in California, and German immigrants were free to enter the United States and reside in Pennsylvania. And in fact, as far as Republicans were concerned, existing naturalization laws already granted citizenship to children born to non-naturalized immigrants who legally resided in the United States, whether in California or in Pennsylvania. By the 1900s, however, Congress began controlling its exterior borders. And the issue is whether the principles that once applied to foreign nationals in the interior now apply to foreign nationals at the exterior. And my paper argues that there's no relevant distinction between the two, at least not in terms of an undissolved foreign allegiance and failure to follow the legal pathways of naturalization. In both cases, children born to foreign nationals who have illegally entered the United States may have been born in the United States, but they were not born subject to the jurisdiction of the United States as that term was originally understood. This does not mean that citizenship for those individuals is inappropriate or should be denied. What it means is that the people retain the right to democratically debate and decide how to address this deeply divisive political issue. Thank you.
Thank you, Kurt. Amanda?
So thank you for inviting me, and I'm looking forward to questions and comments in our discussion to follow. Just a quick reminder about what the Trump executive order states. It states that it's restoring the original understanding of the Citizenship Clause, the original meaning, and it states that under that original understanding, the children of undocumented immigrants are not citizens, and the children of lawful temporary immigrants are not citizens. So just a reminder that that's the debate we're having. Is that the original understanding of the Citizenship Clause? So, of course, I think it's not. I adopt what I'll just for shorthand say is the universalist view of the Citizenship Clause, which is that it includes every child born in the United States, with a few narrow exceptions for the children of diplomats and invading armies, which were the common law exceptions, and children born to Native Americans, who now by statute have been made birthright citizens. And I'll say I'm going to focus on originalism, that's our panel, but I will say I also think that the text supports this interpretation, as well as the specific intent of the legislators, the original public understanding, long-standing Supreme Court precedent starting in 1898 and reaffirmed several times, and the executive branch practice and interpretation for at least a century until January 20th, 2025. So I think all of those sources support this universalist interpretation. But I'll focus on the original understanding because that's why we're here. Keith's done an able job of explaining the substance of what it is that Reconstruction Congress and the nation wanted to do in that 1866 through 1868 period about the meaning of subject to the jurisdiction. I'm going to talk about something slightly different but closely related, which was how did they want this to be implemented in the real world? And it is clear that this Congress wanted a clear, bright line, easily administrable rule of citizenship. That's what they said when they introduced this provision. So Jacob Howard, when he introduced this provision on May 30th, 1866, said that this settles, quote unquote, the question of citizenship and, quote, removes all doubt as to what persons are or are not citizens of the United States, end quote, which is ironic. They thought they were putting an end to this. That was their goal. That's why they had one very clear sentence. We have similar quotes from Senator Benjamin Wade, Senator John Conness. They wanted to create an easy, bright line, administrable rule. They certainly did not want to create a situation in which there would be a case-by-case weighing or determination of citizenship. They certainly did not want to give the question of citizenship to the courts. I think we all agree that the Citizenship Clause was intended to overrule Dred Scott. This was not a Congress or a nation that trusted the Supreme Court with the question of citizenship. In addition, they certainly didn't want to give this question to the executive branch. The president at the time, Andrew Johnson, was not a friend of Reconstruction, and they were openly hostile to each other, the radical Republicans in Congress and Johnson at the time. He'd vetoed the Civil Rights Act the month before, and they'd overruled the veto. He later called for hanging Thad Stevens and other radical Republicans as traitors to the nation. They did not want him or his administration to control citizenship. So they created what I actually think is this beautiful rule. I'm writing a book about this because I think it's such a fascinating and important element of who we are as Americans. This self-executing, self-perpetuating rule of citizenship. You're born here, you're American, you're one of us. No government documentation or intervention needed, which I think might appeal to this group, right? You don't need to have a government official stamp you as an American or weigh your allegiance or protection to this nation before they decide that you are indeed an American. So let's just for a moment think about what would have happened or how it would have worked had the Trump administration's view been what the Reconstruction Congress wanted to do in 1866 and the nation ratified by 1868. Well, there were undocumented immigrants in the United States. Jerry Newman, a Harvard law professor, has a great article from 1993, so it's been around a bit, describing how various states prohibited people from entering in the 19th century if they had contagious diseases or were impoverished or habitual drunkards or other problems. People came in violation of those laws. They were illegal, right? Then, of course, we had the enslaved people who were illegally imported into the United States. The Congress was well aware of those people. It passed numerous laws requiring they be deported to Liberia. So that's another group of people that were undocumented or illegal, and yet were having children in the United States who, if the Trump administration's interpretation was correct, would not have been citizens. There also, of course, were lawful temporary immigrants. The case Lynch versus Clark from 1844 talks about Irish immigrants who came to the US, stayed, and then left. I think it's a little known fact that about 30% of the people who come to the United States as immigrants leave. They don't all stay and decide they love it here. And that was true in the early 19th century as well, and people came as tourists. People came temporarily. You know, Charles Dickens is just one famous example. It wasn't the case that people didn't come to the US and always intending to remain. So then the question is, well, how would you decide and figure out whether someone was either illegally in the United States or temporarily in the United States when their child was born? And that would have been extraordinarily difficult. There were no documents. There was no careful calculation of who was coming in and why they were staying, and if they were planning to remain, and if they'd violated any laws. In fact, that would be tremendously difficult to do today, but it would have been impossible back then. So I've recently published an essay co-written with a fabulous UVA law student, where we looked at the ancestry of 584 members of Congress serving between 1865 and 1871, when this amendment was ratified, debated, drafted, and the Congress, the 41st, which was elected right after it became law. We found at least a dozen members of Congress who arguably would have violated the Trump executive order. They were born to two non-citizen parents, some of them very shortly after those parents arrived. How would they possibly prove they were citizens eligible to serve in Congress? They couldn't have, maybe get their parents to submit an affidavit. There was no documents of whether the parents intended to remain. None of these parents had tried to naturalize before their children were born. Maybe they'd violated the laws of the state when they came in. We don't know. So it would have been impossible for these people to prove they were citizens eligible to serve. But here's the most important point. No one asked that question. no one challenged their eligibility to serve in Congress, even though that was an era when challenges increased enormously. There were hundreds of challenges to people's eligibility during this contentious Reconstruction era period. No one questioned this. And of course they didn't, because they didn't have the Trump administration view in mind. And by the way, anyone could have challenged, not just a member of Congress, but any member of the public. So I'll conclude with this final point. The Trump EO chooses to be perspective only. It's clearly a choice. That's not their interpretation, which would be kind of silly. They say, we'll just apply it going forward. We won't go back in time. But if they were to win this Supreme Court case, they could, of course, go back in time. And this argument that the Trump administration is making would unwind the citizenship of this nation of immigrants. It's not just your parents and whether they were born in the US or citizens when you were born or lawfully present. It's your grandparents and your great-grandparents and your great-great-grandparents. If any one of those people came to the United States without permission or didn't have the requisite intent to remain when your ancestor was born, then you, at least under the Trump administration's view, would not be a citizen of the United States. I just can't believe that's what the Reconstruction Congress intended.
Thank you, Amanda. Okay, so I'm going to give each of you 3 minutes if you have anything you want to say in response to the comments from your fellow panelists, and then I'll have some questions to guide our conversation. I'll go down the line again in the same order. So, Keith?
Okay, so just very briefly then, I guess two points. One is, I don't think that there's a particular Republican argument during the drafting debates that emphasize allegiance as such. Certainly there's not a Republican-Democratic divide on whether or not there's a Democratic theory that says no allegiance and a Republican theory that says there is allegiance. What there is a challenging struggle by members of both parties all through that Congress to understand the best text and best way of conceptualizing how to make sense of Native American tribes and how to draft a rule that's not going to do more than what they want relative to Native American tribes. And they had difficulty settling on language that would accomplish that. They had difficulty explaining the concepts surrounding that, and as a consequence, it gives rise to a lot of awkward statements, including these awkward statements that come from Bingham and Trumbull about allegiance to no other parties. They're inconsistent about that across those debates. They say other things at other points, and so I would not put too much weight on offhanded remarks in particular points. In particular, because this claim that you can only qualify if you have no other allegiance to no other sovereign is radically at odds with the situation that they're confronting in the United States. So I mentioned at the very beginning that the one thing Americans rejected out of the English common law rule about citizenship was the idea of perpetual allegiance. The Americans held the view that just because you were born in Britain and were native-born Englishmen, you were not always an Englishman. You could shed that sovereign authority. Americans were the only country in the world that accepted that view. Every other country adopted the view of perpetual allegiance, which meant in 1866 and 1867, because at that point no other country had followed the United States on this front yet, although it's now become much more common, obviously, is that in 1866, 1867, time of Reconstruction, everyone who came to the United States who was an alien had allegiance to another sovereign and could not themselves ever give that up according to English authorities. Even if you were a naturalized American citizen, you still owed sovereign authority to another sovereign, which was whatever sovereign you were born under. So it made no sense within the context of the time to imagine a world in which you could say that you can only be an American if you owed allegiance to no one else, because the consequence would be no one who was born elsewhere could ever be an American citizen. They understood that that was not what they were trying to say. They're just trying to explain how do we conceptualize this weird situation of Native American tribes. And sometimes they're very awkward in how they try to say that.
Ilan?
Great. I think I'll say sort of two things on Amanda's presentation and then go back to something that I really want to say about Keith's initial presentation that I forgot or didn't get a chance to say, so I sort of thought of on the fly, and so I don't want to miss the opportunity to say it. But on Amanda's point, it's true that they wanted to settle and remove all doubt as to a particular question, right? Whether race was relevant to the question of citizenship, and they did remove all doubts as to that. But to rely on statements like that from the historical record and then extrapolate forward that therefore they intended to remove all doubts about other questions that they didn't really think about or foresee, I don't know if that's how historical analysis is supposed to work, right? I mean, yes, they removed all doubts about the particular questions they were confronting, but it doesn't follow that therefore they were removing all doubts about a question that they really weren't confronting. I just don't think it follows. And it's true they wanted to remove the power from the states to decide a lot of these questions. Does it follow they wanted to remove the power of the federal government? Yeah, maybe not the executive acting alone, but there's Section 5, and so I don't know that you can translate from the disempowering the states to disempowering the federal officials that they thought they were empowering. I do think the strongest evidence is this, against my position, is this negative proof that Amanda talks a lot about, you know, the contagious diseases, the illegally trafficked, the enslaved persons trafficked illegally after the closing of the international slave trade. These individuals in Congress who there's only a handful, I think, in your paper that, you know, like there's some suggestion that maybe the parents were illegally present or temporary, right? But why, I don't know that any of that really matters for the following reason. For the 70 years before the Civil War, there was a single case on the question of temporary sojourners, more or less. Lynch v. Clark. Why? Why was there only a single case in 70 years? Because something had to matter. Something had to ride on the question for the case to be litigated. What was at issue at Lynch v. Clark? Okay, aliens couldn't inherit property, and Julia Lynch's father had a business where the Saratoga Springs kind of equivalent, except I think it was called Congress Springs, a very profitable mineral and soda water business that was at issue. But her dad left back for Ireland just before she was born. And so the other heirs said, oh, she's not a citizen. This is my inheritance, not your inheritance. That's why we get a case, because alienage was relevant to inheritance. A lot of money was at stake, so we get a case. The contagious disease example, okay, maybe if there had been a case, this would have been an issue, but why would there have been a case? Suppose a child had been born. Well, the naturalization rules were super easy at the time. If they had stayed, you know, if there's no property at issue, there would have been no case. So the fact that there were these examples that someone could have maybe challenged it, and the issue might have arisen if there was a challenge, it just doesn't speak to me. It doesn't speak to me. Because, you know, the question is, someone has to have an incentive to make that challenge. I want to say it is some evidence, but it is not dispositive evidence. Let me say one last thing about the question of parentage and is it relevant. There is, in the historical record, a lot of statements, like Bates, nativity furnishes the rule, birth alone. And then there are other statements, like I said, you know, the two parents under the protection of the government. What do you do with the statements, all that evidence, birth alone? And here I'm going to invoke my physics major in college. And I like to joke, don't worry, that's not impressive. If I had been good at physics, I would not have become a lawyer. And it turns out, but for the second time, I think in 2 decades, it might actually help me here by way of analogy. Nativity furnishes the rule is like saying Newton's laws of motion, Newton's laws of physics are correct, are truth. And actually, Newton's laws of physics do answer 99% of the problems. But Newton's laws of physics are not the actual rule. General relativity is the rule. Newton's laws of physics can't explain the orbit of Mercury. General relativity can't explain the orbit of Mercury. It turns out that Newton's laws of physics are just an approximation, a manifestation of Newton's laws of physics, of general relativity, under certain parameters that we experience generally here on Earth. Saying nativity furnishes the rule, like Newton's laws, is a correct statement of the rule 99% of the time, because most people's parents, most people who are born to parents under the protection of the government. But when push comes to shove and it's like, oh, what about ambassadors? What about invaders? What about unlawfully present aliens? That's a question of like, what do we do with Mercury's orbit? Newton's laws don't actually explain that. It turns out the rule was different. General relativity was the rule. And you can approximate the rule. You could summarize the rule saying Newton's laws, but that doesn't mean Newton's laws are actually the true laws of the universe, and it doesn't say nativity is actually the true law of the common law. Okay, I'll stop there.
Well, for any of you who thought that Mercury's orbit would make an appearance in this debate, good on you. Kurt.
Yeah, I was Googling that while he was talking. I'll get back to it. Again, my thanks to the panelists for engaging the depth of this conversation. Keith, I don't have any dispute at all that the framers' statements are inconsistent. I think your words were awkward or inconsistent or something like that. I think the framers' statements were very much awkward and inconsistent with the common law. And so choosing between the two, I'm going to go with their statements over a presumption that the common law informed what they were doing. I think that they had an idea that transcended. It is rooted in some ideas in the common law, but I think that the Republican conception, allegiance-based conception of natural-born citizenship was quite different from the common law. And I think that's why you're struggling to make it fit together. I don't think it was supposed to. And that brings me just briefly to the weird, again to use your language, the weird situation of Native American tribes. For those of us who have been spending time in studying the history of the 14th Amendment, it has always been something of a mystery when we were looking at privileges or immunities or equal protection, something along those lines. It's always a mystery to us when we got to this portion of the debates and they were spending all this time talking about the status of Native Americans. It's stunning. Pages and pages, hours and hours, both during the Civil Rights Act debates and also during the 14th Amendment debates. There was something about the subject of Native Americans and the status of Native Americans that was hugely important in ways that we've lost, that we don't really appreciate. It was a transition point in terms of Congress's understanding of its own authority over Native American tribes. There was about to be a major theoretical shift in congressional regulation of tribal affairs within 10 years after the adoption of the 14th Amendment. Republicans insisted on maintaining the treaty-based approach of regulation with Native American tribes that recognize their quasi-foreign or quasi-sovereign sovereign existence. And it meant that whatever regulations, and there were lots of regulations, but whatever regulations took place had to take place by way of treaty, which involved the treaty tribal members themselves as part of the negotiation. Democrats rejected that idea. They did not want to use the treaty approach. They wanted to assert general congressional plenary power over the Native American tribes. And they recognized that what the Republicans were doing and how the Republicans were approaching natural-born citizenship, that Republicans were in fact entrenching a particular view of the Native American tribes as quasi-autonomous, quasi-foreign nations. And so we got immediate pushback from the Democrats saying they're not groups that we have to use treaties with. We've done that in the past, but we don't have to. We can assert general plenary power. And the Republicans pushed back over and over again. No, the reason they're excluded from subject to the jurisdiction thereof is because they maintain an allegiance to a quasi-foreign government. So those debates are extremely important to understanding their theory of natural-born citizenship, the role that allegiance played, a continued allegiance to a foreign government that was so foundational to the Republican understanding. So I very much encourage everyone, we may talk about this later in terms of sources we think are important, but I think these pages of debates are extremely important in trying to understand what was going on. And then finally, briefly, Amanda, your very important work talking about the status of children, of slaves, of blacks who had been kidnapped and brought into the United States in violation of the fugitives, the trade, the anti-slave trade laws. At the time of the 14th Amendment, as far as Republicans were concerned, once they abolished slavery under the 13th Amendment, all of the newly freed were citizens of the United States automatically. And they treated them that way, and they regulated it that way, and they didn't require any kind of proof of having been brought legally or not smuggled into the United States when it came time to register them to vote under the Second Reconstruction Act. So I just don't think there was any category of children born to former slaves who were brought illegally into the United States. And then as far as why there were no challenges to representatives who were maybe children of people who had not sought naturalization. Republicans actually talked about this during the debates. As far as the Republican leadership was concerned, they believed that current immigration law automatically made any children born in the United States to people legally present, any immigrants legally present, whether in California or on the Eastern Seaboard, that they were already citizens. So no one would have challenged them because their presumption was they were already citizens.
Okay, maybe we'll keep discussing that because I'm quite confused as to how the Trump administration could argue that the original understanding of the Citizenship Clause was that the children of temporary lawfully present immigrants aren't citizens, and yet there was no such category understood at the time, even though we have cases where there are such categories like Lynch versus Clark. And there are many examples of people who come temporarily to the United States and leave without intending to remain. So as a factual matter, I'm not following that at all, but we can discuss. Just a couple of things. One is there certainly were incentives to define citizenship for lots of reasons in the Reconstruction era. First and foremost, voting, and then members of Congress who need to be citizens in order to be eligible to serve. There were lots of debates over eligibility under Section 3, the insurrection provision of the 14th Amendment. Not so much over age, but sometimes over inhabitancy. There was also challenges to people who were Mormons or had some different religion or some different cultural background, which obviously today would not be permitted. But the point is, this was a contentious period when there was lots of incentive to challenge people. And as I've explained, there are numbers of members of Congress, both today and back then, who were the children of immigrants, and no one challenged their citizenship on the ground their parents were either unlawfully present or temporarily present, even though those categories were familiar to the Reconstruction Congress for all the reasons I've said. The one last issue I wanted to address was this allegiance/protection trade-off. So that's an argument made by the Trump administration in its briefs, by Ilan and Kurt, and I'm just confused by it as it would apply to the group that we all agree are citizens, which are enslaved people, whether illegally brought to the United States in violation of those laws that barred international slave trade or not. The idea that those people get citizenship because they had an allegiance to the United States and were under its protection is to me bizarre. If I am kidnapped tomorrow and taken to El Salvador and forced to be a slave, I would not consider myself to be under the protection of that government or owe allegiance to it. I understand you may be using these as some terms of art. It still does not track, and I'll say that it didn't at the time either, because John Brown, when he attacked Harper's Ferry, some of the people with him were enslaved people. And one of those enslaved people was on trial, and he was charged with treason. And he successfully argued, I can't commit treason because I don't owe allegiance to the country that enslaved me. And the judge agreed. He could not be charged with treason. He was hung, just straight old murder, right? But not treason. And this idea that an enslaved person owes allegiance is just bizarre. And it's clear that a whole bunch of people didn't owe allegiance to the US. That was the population of the 11 seceding southern states who had gone to war against the United States of America. And yet I think we all agree their children are also citizens. So I'm just confused by the allegiance protection trade-off and how it's being used in this conversation, and I don't think it tracks with the original understanding either.
Okay, so I have a few questions, and then we'll open it up for audience questions in a bit. There's obviously a lot of disagreement among you all on this very important question, but I actually heard a lot of points of overlap among the four of you, and in your papers as well. I saw a lot of overlap. I want to know if my reading of this is right. Despite your different emphases about different sources of evidence, so Kurt, your focus is more on the actual ratification debates. Amanda, your evidence tends to come from kind of dogs that didn't bark, the kinds of examples like you were saying. But it sounds like all of you are of the view that the 14th Amendment Citizenship Clause was declaring and entrenching the common law rule with alterations, for example, to say, to resolve that race had no relevance for the rule moving forward, but that it was trying to entrench this common law rule, and you're disagreeing about what that common law rule was, what the contours of it were. Is that right, or do any of you disagree with that? Do some of you think that it's not about the common law rule?
I think that's right, and it's an important point, because a lot of the earlier scholars who've written about this like Shuck and Smith and John Eastman and others, I think their view is that they reject the common law, or they argue that the Americans, after the American Revolution, rejected the common law, which they described as ascriptive, accident of birth. And what at least I've been arguing, and I think Kurt has been arguing, is that, though maybe Kurt focuses more on the legislative history than I do, but certainly what I've been arguing is that actually the common law rule is not what conventionally it is thought to be. So I think that's right.
Yeah, and even you, Kurt, I mean, in your piece, you lay out the common law rule before you get to the 14th Amendment
Right.
debates, right? So.
And so, but the reason I do that in my paper is that I'm investigating how theories of citizenship were debated, and that involved discussions at the time of common law, and how we struggled with different ideas and different interpretations of the common law. And one of the things that I trace in my paper is how slowly but surely began to move away from considerations of soil, this pretending that children to ambassadors were born on embassy soil, which was really the soil transferred from a country far away, to more just a simple understanding that it had to do with the foreign allegiance of the parents. So I trace how that idea eventually informed the Republican understanding of allegiance. But I think I probably take the strongest position here of rejecting the idea that you start with the common law. That actually is very important to my particular thesis. And some of my reasons for doing so, Keith traced out in the beginning of his remarks, the common law was under stress from the beginning after the American Revolution and as we entered into the constitutional period. Yes, some aspects of common law were maintained, but other aspects of the common law were increasingly viewed as inappropriate in the American context of popular sovereignty. And a lot of my work has focused on how ideas, common law understandings of freedom of religion and freedom of speech that might have been in place and been influential at the time of the founding, actually radically changed, at least from the perspective of Republicans and abolitionist Republicans in particular, who engaged in so much inflammatory religious-based activity and speech. So I think, again, you just can't go into the Reconstruction debates and presume that standards or doctrines of common law are going to help you. So rather than rejecting the common law, I simply believe that you start with the text, you start with the statements of the people actually who were involved and let them speak for themselves, rather than bring an assumed baseline common law understanding of what they're trying to do.
The exceptions to citizenship on the basis of birth in the United States are obviously very important to this debate, and you all touched on them in your remarks, and you touched on them in your papers. Another question I had about potential point of commonality, I took all four of you to be saying that those exceptions are not sort of arbitrary carve-outs, but have some principle that explains them that is consistent with the general rule, whatever the general rule might be, such that, and the reason why I think if that's true it's important, is such that whatever the principle is that explains these exceptions would, in principle, apply beyond those exceptions to other categories potentially. Whether that applies to aliens not lawfully present, obviously that's a huge point of disagreement, but that in principle, it's not the case that you just have a closed set of exceptions that don't have something that explains them. Is that accurate as well? Do you all agree on that?
I think that's right. Moreover, it raises a point that I think it's worth mentioning. So Ilan, during his initial remarks, sort of objected to my characterizing these as exceptions, that they're better understood as qualifications. I think that's totally right. They were commonly characterized as exceptions of the period, and I just adopt that because that's the standard language everyone uses, including in current scholarship. But I think it's better to understand them as scope conditions.
Yeah.
They qualify and explain what the limitation is of the underlying rule. They're not really carve-outs of the rule properly understood.
Okay, so if there is at least substantial common ground about maybe not that that it just is entrenching the common law rule with Kurt's kind of a pushback on that, but that there is a rule that is at least originating in the common law that they are perhaps modifying, to Kurt's point, and that there are these exceptions that have some sort of principle that you might be able to extend. then it does seem like the real debate is just, well, what is the through line here that explains this historical evidence? And there I'm curious whether there are intra-positional disagreements. Like Ilan and Kurt, do you guys disagree in any substantial way on how to explain the historical evidence? Keith and Amanda, do you disagree in some substantial way about how to explain the historical evidence? I'd be curious to hear about that.
Just to briefly jump in on that one, because it goes to a point that Amanda, you raised a second ago. I do not adopt the protection argument that Ilan has developed. I think Ilan's work is extremely important. But I think and in a lot of ways, Ilan, I think you and I are kind of pursuing parallel tracks, and we end up very close to each other in a lot of ways. But I think methodologically, starting with the debates themselves, has led me to an idea of the Republican theory that isn't triggered by government, by concerns about whether or not government protection exists. I think one of the reasons why I depart from that is because the view of the national government is that they were engaged in protection of the Native American tribes, and the treaties expressly use that language. So I don't find that particular idea helpful to my understanding of what they were doing with allegiance to a foreign nation. So there are disagreements there, but at the end we come very close. One of the places where we also maybe depart is the idea of the status of children of foreign nationals who are only temporarily in the country. I think Amanda's quite right. We have not addressed that particular issue, which I find to be extraordinarily difficult, and it is one that is a major challenge. So I appreciated your pushback on that.
And Amanda and Keith, any disagreements between the two of you think?
I don't disagree with the common law analysis. I would say I do not think that the Reconstruction Congress was looking to replicate the common law and nothing else. I think it was all part of their anti-caste equality agenda, which is indicated by several other provisions in the 14th Amendment and much of what they did and said. But I don't disagree that they were referring to common law and bringing those exceptions in and no others.
Can I jump in on the?
Sure, please.
I do think this is interesting that Kurt mentioned this, because as I'm thinking this through, I do think he and I disagree about the concept of allegiance as well, not just protection, and that this might affect our answer to Amanda's challenge, which is a good one. So when Trumbull says owing allegiance to no one else, I actually don't exactly know what he means by that. Because at common law, the meaning of that phrase would have been as follows. At the time of birth, were the parents under the ligiance, under the allegiance, under the power of this country and no other country. Ambassadors were under the power of another country, even though physically in our country. Invading armies were under the power of another sovereign while physically present. So allegiance or ligiance had a dual meaning at common law. From Coke onward, it meant being within the power and jurisdiction of the king, and owing a loyalty or fealty to the king, which is actually why I don't really rely on Trumbull's discussions of allegiance, because he's not necessarily using allegiance in the way we today say, as in like, oh yeah, I love this country, I have a loyalty. Allegiance had that meaning, a duty of loyalty to the country, but it also meant being subject to the power of the sovereign. And if that's what he means, like, I just don't know. I think that's perfectly consistent with the common law rules of protection and allegiance. You get protection, and in exchange you owe allegiance, meaning you submit to the power and rule of the king. And so I think I agree with Keith that that's what allegiance and protection meant. And so how does this explain the example of the Confederacy? No one doubts that the Confederates who rebelled were, before their rebellion, under the allegiance of the United States, which is why they could be tried for treason. People who came without permission, without the protection of the sovereign, enemy aliens, spies, they could not be tried for treason because they never had been under the protection or within the allegiance of the sovereign. They came as enemies, right? And so they were subject to martial law, not the municipal law of treason. The enslaved category is more difficult, but we're not actually dealing with the enslaved category. We're dealing with formerly enslaved persons, now free persons, born, present, living in the United States, lawfully under the laws of the United States, no longer have this condition of servitude, and they discuss this. And Schellenberger says, look, enslaved persons are unlike aliens. It's a different category. They're subjects, they're aliens, and then there's this condition of servitude. The only reason they were not citizens under the common law was their condition of slavery. We've abolished that condition. And he even said they owe allegiance to no other government. He didn't use the language of protection, but he did even say that once they are freed, if they choose not to leave, they could be understood to have consented to be here. And so, and again, if allegiance means what I think it means, which is being within the power of the king, and within the jurisdiction of the king, and under the protection of the king, formerly enslaved people, now freed in the United States, fit that bill perfectly.
So there's a lot of historical evidence to sift through here, like centuries of evidence if we're going through the common law sources as well. And it can get kind of overwhelming to sift through this. And I think it would be helpful, certainly I would find it helpful, if each of you would just articulate what you think is the most powerful historical evidence in favor of your position, of how you interpret the citizenship clause. If you had to tell people here, go read this, this set of sources, what would it be? Keith.
So this is a single thing, it's hard to say. For me, going back through all the history, which there's a long history that I'm trying to figure out, of the English common law and the American understanding of English common law, is really just trying to unpack, well, when there's these brief references in the drafting debates or in Edward Bates' opinion, what do they actually mean? What's the rule that they're carrying forward? And so it's unpacking all that history that makes sense of this brief reference that they say, well, everybody knows this. And then it's a question of, what does everybody know exactly? I think if you want to read one thing, though, that gets you going is the Edward Bates opinion on citizenship, which does have like 2 paragraphs on this particular point in which he sort of says, and there's some standard sites you can go look at, but it does engage and explain sort of the setup of what the debate is moving toward and why they're worried about this kind of issue in general, what they're trying to take off the table, what's still on the table for their purposes.
Great, Ilan?
So there isn't like one source, right?
Right.
But I would say for the rule, Story's single sentence description, I think, is a correct summary of the common law rule. For the relevance of safe conducts, Blackstone describes it perfectly. You need a safe conduct to be under the protection of the king, right? You connect the two together and you get, I think, the result that I'm discussing. On temporary visitors, which I didn't mention, there isn't like one piece, right? Lynch v. Clark is obviously the best piece of evidence against my view. We didn't talk about it today, or I didn't talk about it today, but I do think the common law rule as to temporary visitors became contested. People were arguing there should be a qualification to the rule, or that there was a qualification. A couple treatises mention this, but the best piece of evidence for me on temporary visitors, which you will find first in the article that Keith, I'm publishing in the same journal that Keith is publishing, is the question of Louisiana military authorities. The Department of the Gulf during the Civil War was presented with the question whether they could conscript into the Union Army children born in Louisiana to French parents, to French subjects. And this was litigated in the provost courts. The commanding general of the Department of the Gulf issued an opinion about this, and they concluded that they could conscript such children only if their parents had been domiciled, and that you could not conscript even children born in Louisiana of temporary visitors. And so you could claim exemptions. Anyway, so this is a way of suggesting that, of course, if they had been citizens according to the common law rule, then they were subject to all the obligations of citizens too. This, I think, is the best evidence in my favor, saying that the common law rule was uncertain as to the application of temporary visitors, and also that temporary visitors are not subject to the complete jurisdiction of the United States in the sense of the amendment, because many people thought you could not conscript children born of temporary visitors, or you could not even conscript the parents who were temporarily visiting into the army, which was a limitation on the exercise of the sovereign's jurisdiction.
So before we get to Kurt on this, my apologies for not mentioning what journal your pieces were being published in. I didn't see that on your SSRN version.
You all know it.
Where's it being?
You all know it. The Harvard Journal of Law and Public Policy, coming out in.
Okay, great. Thank you. Okay, Kurt.
Congressional Globe, 39th Congress, first session, pages 2890 to 2897, May 30th, 1866. Go. That's it.
Excellent.
By the way,
Okay.
and that, of course, is part of, Amanda actually quoted part of those debates, extensive debates between Republicans and Democrats regarding their theory of natural-born citizenship.
Section 1 of the 14th Amendment. I just want to quickly remind people that until January 20th, 2025, and this president, there hadn't been debate about this. The previous debate we had was in 1898. The US government argued before the Supreme Court that no child of anyone who wasn't a citizen, so it wasn't this temporary immigrant versus or undocumented immigrant, it was if your parents weren't citizens when you were born, you weren't a citizen. An extraordinary argument to make, right? Because it would have taken away citizenship from thousands of people, some of whom were voting and holding office. The man's name was Holmes Conrad. It was 1898, he was Solicitor General, he'd formerly been an officer in the Confederate Army, and in addition to making the sweeping argument, which he clearly wanted to prevent the children of Chinese immigrants from being citizens, in this case, Wong Kim Ark, in addition to making that argument, he also argued before the US Supreme Court that the 14th Amendment to the US Constitution was itself unconstitutional. As far as I know, it's the only time that anyone, certainly the US government, has told the Supreme Court that a provision of the Constitution is itself unconstitutional. That is the precedent we have, and until January 20th, 2025, we have not had anyone else questioning what I think is supported by the plain text of Section 1 of the 14th Amendment.
So I have one more question for you before we turn it over to the audience, but we can start lining up for questions from the audience. The microphone is right here. When I do turn to you, ask a brief question and an actual question, or I will cut you off, because I'm sure there's going to be a lot of interest. I want to make sure we get through the question. So last question to you all from me. We've been focusing on the constitutional question, the constitutional issue, this entire panel, but obviously there's also the statutory issue that is granted in Trump versus Barbara, and that might be a different analysis, maybe it's the same analysis. That's actually my question to you. If any of you have any thoughts about how the court should think about the statutory question and whether the executive order is contrary to the 1401 of the Nationality Act, I'd be interested to hear whatever you have to say about that.
I'll just say for those interested, Professors Chris Collin, Rachel Rosenblum, and Jerry Newman have written a terrific amicus brief about the history of this provision of the INA, which tracks the language of the 14th Amendment as a statutory matter, giving universal birthright citizenship. I'll just say it's not the only provision of the INA. If the Trump administration executive order is correct, we'd have to rewrite the INA because it presumes throughout that if you're born in the US, you're a citizen.
So the statutory, as Amanda just said, the statutory language just mirrors the constitutional language, which actually gives support to what Trump's attempt to interpret it for his purposes, right? Just like Lincoln, after Dred Scott, had to decide who was a citizen of the United States after the Dred Scott ruling. Were free black persons citizens of the United States, notwithstanding the Dred Scott decision for purposes of issuing coasting licenses or passports. And Lincoln said, I think Taney was wrong, and he issued them the coasting licenses. So this is and passports. And so this is like an interesting departmentalist point. But of course, if the statute itself, in that case, or in this case, has a different meaning, the executive can't go beyond whatever that meaning is. So again, it mirrors the language, and I think one possible outcome here is that the court avoids the constitutional question and says that the statutory language means anyone born irrespective of illegality, temporary status of the parents, because that's what the legislators thought they were doing, and there's some evidence, not a lot, but I mean, it wasn't like there was tons of debate about this, but there is evidence, significant evidence that some legislators thought this, important legislators thought this. But that does so that would be a nice solution to avoid the constitutional question, but it would be awkward for the court to do it because it would have to rely on legislative history rather than the text, which itself just mirrors the constitutional provision. And is Chief Justice Roberts going to say, who loves to avoid the constitutional question if he can, but would have to rely on the legislative history to do so in this case? Is he going to do that? I don't know. Start your betting.
Kurt, Keith, any thoughts on this, or shall we go to the...
I'm not sure. I mean, obviously, there's a lot of speculation that this might be an off-ramp to avoid the constitutional question. I'm really not sure they can. It would be, if they decide that the statute, even though it uses the language of the 14th Amendment, means something different than the 14th Amendment, And suppose the court thinks that they're wrong, the Congress thinks that they're wrong. Suppose Congress thinks, no, actually that statute was only supposed to mirror whatever the correct understanding of the Constitution was. What is Congress supposed to do about it? Repass the statute and use the same language again and say, but this time we really mean it? Or do they have to say, we really mean, it means the language of the Constitution, but we have to use different words to say that because you don't think that's what those words mean? It's a mess. It'd be an absolute mess. I think the court should just address the elephant in the room and talk about the meaning of the amendment.
Anything to add, Keith? Okay, we'll go to questions from the audience. Please.
Professor Frost, I heard you say that you thought it would appeal to this audience back.
Libertarians anyway.
Well, I was wondering what you meant by that it would appeal to this audience to not have to present a lot of documentation to prove citizenship.
Maybe I'm wrong about the audience.
Well, I mean, yesterday we had a panel on this book, Abundance, by Ezra Klein and another author.
Right.
And yeah, we had a good discussion on that. And it's all about not having to go through a bunch of red tape and documentation and stuff. And so, I mean, this might be a limit, I think, to what this audience, maybe we should have some documentation for proving things like citizenship. I mean, and I mean, I personally think it was in the discussions before Trump. I mean, there was the phenomenon of birth tourism going on, a lot before Trump brought the issue up. But yeah, what do you think? Is that an appeal, really, to not have to produce documentation to prove you're a citizen?
Yeah, so first of all, I don't mean to presume what anyone else thinks. Maybe you want more government.
Presume.
Well, I testified about this issue before a House subcommittee that part of its title was limited government. And I made the point that if they like the Trump executive order, they're calling for a lot more government involvement in people's lives at the moment that their child is born. But I take your point, which is you're saying I don't agree. I think you're saying I don't agree that just because there's less government in my view of the Citizenship Clause, that makes it an appropriate or a good approach. One quick thing to say about birth tourism. I talk on this issue a lot, and I at first had thought birth tourism was a sideshow, but lots of people are concerned about it. So a couple things to say about it. One, there's already a regulation that makes it illegal to come to the United States for the purpose of having a child that would be a citizen. And there are many stages at which that could be vetted, including when the person is entering the United States. So, and you're allowed to just ask people questions or bar them if you think that's why they're coming in, and you're a Customs and Border Protection official. So obviously, pregnancy is a very visible condition at the end of the pregnancy, and I have FOIA'd for how often this is being enforced, but for those who are concerned about birth tourism, enforcing that regulation might be the better solution than taking away citizenship and questioning it for a large group of people.
If I may to support, and support the question and support the premise behind the question of the difficulty of introducing situations where it might be difficult to prove whether or not you're a citizen of the United States and the status of your parents. I think that Akhil Amar, in one of his podcasts, talked about the case, the intuitive case of what do you do with a child who's left on the steps of the Kansas City schoolhouse, or courthouse, and we don't know anything. We don't know anything about those parents. This is one of the reasons why my article is titled "Prima Facie Citizenship." I think there are two considerations in play. One is, what was the original understanding of the 14th Amendment? And then two, how do we construct a doctrine that puts that appropriately into play? And what I talk about in my article is that I think it would be an appropriate construction to grant prima facie citizenship to any child born in the United States, absent evidence of some type of refused or rejected allegiance to the United States, or formal maintenance of allegiance to a foreign sovereign. And I think that would be perfectly appropriate and would involve a lot of these difficulties of making someone prove that their parents had a particular status.
Can I add just sort of two personal anecdotes on both points raised? The first is, I spoke at Vanderbilt on this topic, and there was a British student, or not yet, who came up to me and explained to me that the rule in Britain has changed. The rule is not birthright citizenship anymore. So right as we were sort of codifying it, they moved away from it. And he explained that his parents, who were American, were on a temporary visa when they were in England when he was born. And so he had to naturalize, whereas they were permanent residents by the time his two siblings were born, and so they were natural-born citizens. And it's like, the Brits can do it, we can do it, right? So that's just sort of an anecdotal point about that. The administrative thing, we do administrative things all the time, and I don't see why this would be particularly difficult to administer. On the point of the debate, I mean, there was some debate, right? I mean, there was the Shuck and Smith piece book, and it was the most prominent. But this, I think, goes to a broader question of academic incentives, right? And so if I may be very personal for a moment, like I've been asked, like, oh, why did you choose to write about this? And because I didn't write about it until after Trump issued the EO. I do have a book on Section 1 of the 14th Amendment, in particular the Due Process Clause, the Privileges or Immunities Clause, and the Equal Protection Clause. And I didn't touch on birthright citizenship. I saw materials related to it because Allegiance for Protection has something to do with the Equal Protection Clause as well. But I didn't write about it because why would I have written about it? The time actually that the book came out, I wasn't even tenured, so that was one thing. When the Trump EO came out, I was tenured and I'm at the University of Minnesota, and I had to decide, okay, now this would matter. There's a reason, there's some benefit to my writing this. But there were going to be costs, and I had to decide, you know, is it worth, like, am I ready to spend the rest of my life in cold, bitter, just kidding, the cold is actually totally fine. It's the humidity that sucks in the summer, but okay, that's everything. You know, am I willing to stay the rest of my life in Minnesota? Because there will be professional repercussions. You know, because people say things like this is beyond debate, and they make it sound as though arguments that are made are beyond the pale. And I think this is a broader indictment of the academic echo chamber and ecosystem than it is about the arguments that I'm making about birthright citizenship.
Next question.
Great. Can I introduce myself? I'm Kim Rubenstein. I'm a professor from Australia visiting. I'm about to teach next week at Columbia Law School a comparative citizenship law course. And I've argued 3 matters before the equivalent of the Supreme Court in the Australian High Court around citizenship. And there is a very interesting contrast in that the Australian framers of the Constitution chose not to include a provision about birthright citizenship, but with a presumption that the common law principle would apply to British subjects. And that case was actually, the fact of that was actually litigated in 2004 in a case that I was involved with called Singh and the Commonwealth, where someone who was born in Australia when the laws had changed, as Ilan had said, similarly to Britain in Australia, it's a legislative provision that changed in 1986. Up until 1986, birth in Australia meant that you were a citizen. After 1986, the legislation was changed in order that one of the parents had to be a permanent resident. A child born to temporary residents sought to claim that the original interpretation of the provisions around citizenship should apply to read into the Constitution that birth in the territory was sufficient to protect you from removal. That case might be interesting for the current discussion because each of the High Court judges had to go back to the common law principles of that period, the equivalent period, and analysed what the laws in relation to the common law conception of birthright citizenship was. And so I guess this is a question to all of you and to a question more broadly about the US Supreme Court. To what extent do you think you should be looking at other common law jurisdictions who have had to deal with this question as to how we interpret the provisions as they were understood at the time, provisions that were very much influenced by the international legal principles of the time in relation to birth of diplomats outside of the region and to enemy aliens as opposed to aliens, friendly aliens. So it's a sort of a broad question about an approach to comparativism as well as the extent to which those common law principles should be interrogated a bit more around the world.
Could you repeat the outcome of that case?
Yeah, what was
did
the outcome?
whole
Sorry,
thing, or
I
you
did
may not
not.
have mentioned it, but
So the outcome was that it was because it wasn't constitutionally entrenched, it was within the power of the legislative of the Parliament, the Congress, to change it, and that child did not fit within those principles. So it protected the legislative change. It did not affirm an implied birthright citizenship.
it's a difficult question.
But I guess it's the broader comparative and how much any of you have looked at other Supreme Court jurisdictions that have common law, decisions that are around this very point.
I guess from my perspective, right, the key issue is what kinds of considerations and principles and rules we're factoring into the writing of the relevant text and the debate surrounding that relevant text. And in the context of the Reconstruction text, they were looking back toward the English common law as they understood it and as it had been integrated into the American law as such. And so as a consequence, English sources become extremely relevant, but they're all old English sources, yes, not new English sources, and certainly no comparative sources that post-date the drafting of the text in question.
I think with an older way of looking at law, it of course would have been relevant because, really, if you go far back, statutes themselves were evidence of a law, not law. We don't really think that way anymore, but certain common law precedents were just evidence of what the law actually was. And if you could show that in Australia they still do that way, they still have that way of thinking, and that in America we still have that way of thinking, absolutely, I would cite it. I'm inclined to cite it anyway if it supports me, but no. But I do think we need to establish, that we both still do law this way, and I don't know that we do, and I don't know that they do, but a fascinating. I'm not beyond looking at how other legal systems have done certain things, right, when there's ambiguity, right? Because it's like, James Madison said in 1791, right, if a constitutional provision is ambiguous, it is triable by its consequences, right? And the consequences of particular interpretations can be seen by the effect of those interpretations in other jurisdictions that are similar to ours, including in Australia and Western Europe, England, the UK. And so I'm not beyond looking at those sources for that reason. And I do think subject to the jurisdiction is ambiguous for the reasons I said, because they meant complete jurisdiction, and it turned out you needed protection to be amenable to sue and be sued, and so it's like it might seem obvious by just reading it, but I don't think it is. I don't think it is, and that opens up avenues to look at other sources. So maybe we still could. Thank you for your question.
Any other thoughts?
I'll just quickly say that Eric Foner said birthright citizenship is the good kind of American exceptionalism for reasons that relate to, I think, what's unique and frankly fantastic about the United States of America, which is that we are this enormous pluralistic, immigrant pluralistic population that has so far managed to hold together in this American experiment. But I will just say quickly, relating to the point about what other countries do, Ilan, I agree that it wouldn't be that hard today to show whether parents are green card holders or not, although there's many muddy categories. But the question I thought for this panel was, what did they think they were doing in 1866 and through 1868? And there were no such categories or documentation to suggest whether someone was staying permanently in the US or not when their child was born. So I don't see how they could have had that as the original understanding. And I'll also say that the US rule, as interpreted by President Trump in the executive order, is far more restrictive than the English or the French rule. I'm not familiar with all of the European countries, but their rules allow people to become citizens. For example, in France, your parents are undocumented, but if the child remains in France through, I think it's the 18th birthday, they're automatically a French citizen. Whereas the Trump administration's executive order certainly does not provide that. And in fact, if they got rid of the prospective-only application, which is entirely their discretion to do that, if they win the Supreme Court case and choose to get rid of it, it's not just your parents. As I said in my opening remarks, you'd have to prove every ancestor going all the way back. The people who are green card holders who have children in the US, they'd have it the easiest to prove the citizenship of the children. My parents and grandparents and great-grandparents have been in the US. I'd have to go back and see if any of them violated immigration laws, and there were limits, or if they'd come temporarily. And that would be extremely difficult to do in terms of paperwork.
Next question.
Just briefly, if I understand, I love the fact that comparative law and different situations is brought up here. If I understand this correctly, I think it's a beautiful example of people deciding to depart or modify the common law. So I love it. I think it's very helpful. I agree with Amanda, though, that as much as we can look at how the administrative regime is set up today, if we're doing originalism, we have to think about how this might have worked at a time when you didn't have that regulatory apparatus, and how would they go about understanding temporary or proving temporary domicile or entry into the United States? I went in this regard, and again, I'm just going to confess I find it very difficult, and that's why I err on the side of expansive birthright citizenship for people here temporarily who are legally present. There are people doing great work on this at the time of the 14th Amendment. I think Amy Swearer has come out. And you might have, I don't know, Ilan, if you mentioned her article. Amy Swearer recently posted a fascinating article about conscription at the time of the Civil War and how there were discussions about whether or not remember, there wasn't a federal citizenship, but it was state citizenship, and there was a question as to whether or not recent immigrants could be conscripted into the Union Army. And there was an in-depth political and public and political debate regarding what you had to do to signal that you had transferred your allegiance from another foreign government to so embracing citizenship in the United States that you now had a duty to defend the United States. So that there are pockets of discussions regarding temporary presence and its impact on natural-born citizenship that other people are working on, and I just want to flag Amy Swearer's work in that regard.
Since we only have two questioners left and we're running out of time, I'm going to ask the two questioners to just briefly state your questions. We'll go one after the other. That way the panel could address both questions to the extent that they wish. And if we go a couple minutes over, I think that's fine. So please go ahead.
Sure. In my forthcoming book, Taking American Citizenship Seriously, sorry, I had to say it. There's one thing I didn't address, and I wanted to know if anyone on the panel happens to know any instance before the 14th Amendment of persons born in the United States being naturalized under the federal laws.
I'm sorry, I missed that. Could you say
Any
that?
instance of persons who were born in the United States to immigrants feeling like they had to be naturalized under the laws of the United States, under the Naturalization Acts. I'm not aware of them, but if there's zero, that's an indication that you had fairly broad native-born citizenship.
The parents were aliens.
Yeah.
The child was born.
In the United States.
And then the question was whether the child was naturalized.
No, when did the child ever even have to be naturalized?
Whether they felt obligated to seek naturalization.
So
let's quickly.
I'm sorry.
Yeah.
Interesting question.
I have a question for the originalists. What about liquidation? Ilan just said the provision is ambiguous. Ilan just said, James Madison thought when it's ambiguous, it gets liquidated.
Hoisting me by my own petard.
For 100 years. For 100 years, everyone has assumed. The answer to this was, if you're born here, you're a citizen, end of discussion. When they passed that statute in 1952 using the words, that's what everyone thought those words meant then. Why doesn't that answer this question?
Okay, can I do both? And then I'll stop. And I will not say another thing. David, that's a great question. The problem is that the naturalization statutes provided that the moment the alien parent naturalized, all of his children under 21 years old naturalized with him. Okay? And so most aliens came to settle and most naturalized. And the naturalization statutes at the time did not distinguish between children born in the United States and whether they had to naturalize. It simply said all their children under 21 are naturalized with the alien parent. So it would have been extremely rare to have some situation of someone born in the United States whose parent did not naturalize, and then they nevertheless claimed citizenship, and that was without naturalization, and that was Lynch v. Clark. Right? So that's an example of that, and the judge in that case concluded she was a citizen without having to naturalize, right? But that was the only case because, again, something had to write on it, and because the naturalization statutes provided that all the children naturalized anyway. And so it's like you're just not going to find that. So again, negative proof is interesting, but it has to be understood in the context of like why we would have to expect to see it for it to be probative of something or someone to challenge. And here it'd be so rare, right? Because most of the alien parents did naturalize, and so their children, born or not born, would be naturalized with them. On the liquidation point, I appreciate the attempt to trap me. But this 100 years of precedent and custom and liquidation, I just don't believe that to be true. Okay, so here's what Wonka Mark says. Every citizen or subject of another country, while domiciled here, is within the allegiance and the protection, and consequently subject to the jurisdiction of the United States. They repeat a second time, Juan Camargue's parents are entitled to the protection of and to allegiance to the United States so long as they are permitted by the United States to reside here and are subject to the jurisdiction thereof in the same sense as all other aliens residing in the United States. This is not a holding, right, because that wasn't an issue. They were domiciled. It wasn't, the question wasn't presented squarely because the parents were lawful and were domiciled, right? But nor is this evidence for liquidation of the view that if the parents had not been domiciled and had not been lawful, their children would have been considered citizens. That view, as far as I know, did not even make it into State Department manuals until the 1990s. Maybe it was like the 1980s. That is not a century or century and a half of sort of liquidation on the other side of this.
I just want to say quickly, and Ilan, I'd love to get your sources after, because I disagree that most immigrants to the United States naturalized. They were trying to hold body and soul together. They were neither then nor now do they most of them naturalize. And historically, about 30% of immigrants to the United States returned home. We don't have good data for the early 19th century, but that's from the mid-19th century on. So I'm just disagreeing with you on the factual matter and would love to get sources. I'm actually going to, I have a work in progress, so I want to make sure I get it right, and I could be wrong. I'm willing to defer to your facts, but my understanding of the facts is not, it's not consistent with that.
Any other thoughts from the panel on the two questions?
I'll just say I don't think this is ambiguous, and so I don't think there's a need for liquidation. In addition, I am not a huge fan of liquidation as a concept in general, and so I don't think that's terribly meaningful. But I do think that there's a century and more practice that generally leads to the conventional view and is mostly consistent with it. And so I do think that ought to weigh heavily in how we think about whether or not we want to make radical departures and what we thought was correct. But if it turns out we, in fact, were not correct for 100 years, I'm willing to revisit the things we were not correct about, because that's the nature of an originalist text.
Anything, Kurt?
No, I agree.
Well, I thought this was a very valuable panel, so please join me in thanking our panelists.